Good afternoon, everyone. Thanks for getting on the NERCA webinar. My name is John Ferrante, Director of Government and Industry Relations for NERCA. We have Philip Siegal, an attorney with Hendrick, Phillips, Salzman Siegal. They do a lot of great, legal work for us at the convention and definitely through these webinars. And I know they work with a lot of our contractor members. So we have a good webinar today, taking some real life experiences and trying to learn the lessons from them. A few housekeeping items. Philip does intend to, stop periodically and ask if anyone has any questions. If you do, there is a chat box or a questions box. If you want to just type in a question into either one of those, I'll be able to pass it along to Philip and hopefully get an answer. If we are going to keep everyone muted during the presentation just to kind of keep down the background noise. And also we are recording the webinar as well. So if anyone wants access to that recording afterwards, we can send you a link. We're going to put it up on our YouTube page. So yeah, with that, I guess I'll throw it back to Philip and hopefully everyone enjoys the webinar.
Yeah, great. John, thank you for the introduction and thanks everyone for attending. As John noted, what I intend to cover here over the next hour are actual cases I've handled, all within the labor and employment arena. And then at the end, I've got a couple of questions that are being asked with some frequency in my practice that I thought would be a good opportunity to address those as we conclude. In terms of the actual employment-related claims I'll be talking about, I'm going to start off with the wage and hour issue. I will transition to a matter brought before the EEOC, a disability discrimination case. And then I've got two OSHA cases, one dealing with controlling employer and one dealing with the unforeseeable employee misconduct defense. As I transition from each case to the next, I will ask John if there are any questions pending. You can use the chat box for that purpose, and I'll make sure that I answer all questions before I wrap up when we conclude this afternoon. So let me jump into it with just the first case that I refer to as the case of the open time clock. Now, this particular contractor is in mechanical contracting. It doesn't matter that they're not in roofing. What I think is critical is that this is a company that maintained a job site trailer at their job sites, and they had a process by which employees would arrive at the job site. A time clocking system was kept on the foreman's computer, and the computer was there in the job site trailer for employees to sign in at the beginning of the workday and to sign out at the end of the workday. What is unique in this instance is the employer's workday begins at 7 a.m. And because they begin at 7 a.m. here in Atlanta, they had employees who, in an effort to avoid traffic, were getting to the job site and into the job site trailer as much as 30 minutes before 7 a.m. And when they were doing that, they were clocking in at the 6:30 time. And what the employer did not account for the time between 6:30 and 7. In fact, the time clocking system was set up in a manner that when the employees clocked in any time prior to 7, the earliest check-in time in this analysis, and this gets into the throes of a Department of Labor wage and hour audit. I'm going to get to that in a minute. But the system was set up that it automatically rounded up the time to 7 a.m. And the company's thinking was, we have employees that are getting in maybe as early as 6:30, but they're around the job site trailer, they're drinking coffee, they're smoking a cigarette, they're just hanging around, they're not doing any work because our work doesn't begin until 7 a.m. And they even had an argument as the audit goes forward that we can't do our work in the dark and the sun doesn't start to rise until after 7, but we pay effective as of 7 o'clock. Based on our time clocking system. Now, this contractor, and where I find companies are more likely to be subject to a wage and hour audit, they were working on it was a private construction project in a highly visible area. This happened to be right off the expressway downtown here in Atlanta between where the offices are and Centennial Olympic Park, right off the expressway, highly visible project. And sure enough, the Department of Labor swoops down on the project, and the various trades that were on site at the time of the Department of Labor's arrival are subject to a wage and hour audit. And the way this process begins is the Department of Labor issues a letter, and they're handing out the letter, and the letter identifies a date and time by which they're going to formally appear at our client's office, and they are going to be asking for documents pertaining to their investigation. I've identified a couple of them here. I'll go back up a page. The documents are identified right here at the bottom, and they continue to the next page. And they are also sitting and looking to interview not only our officers that run the company and the people that manage the payroll system, but they also want to verify and have the right to interview the employees. And when they interview the employees, they're asking about this timekeeping system and how it works, what time they're arriving, and they're gathering all this information. Now, importantly, the company did have a policy in its handbook regarding time clock use. And despite having the policy that talks about not punching out or punching in no earlier than 5 minutes and no later than 5 minutes on the back end of the day, this policy was clearly not enforced, which was mistake number one. We had employees arriving at the job site trailer, again, as early as 6:30 and clocking in. And while the company believed that these guys were not performing any work, a very important point to be made next is that during the interviews conducted by the wage and hour investigator, the investigator learns through the employee interviews that these employees are actually going beyond just hanging out. They're reviewing plans, they're making reviewing plans and drawings. They are getting things organized for the workday that's about to follow. And those activities are actually work. So the government takes a position that, hey, when these people clocked in, it's one thing when they clocked in early and they weren't performing any work, or if they clock in late and if the end of the workday is at 3:30 p.m. and they're clocking out at 3:40, but they're not doing any work between 3:30 and 3:40, we would disregard that. And in fact, I've got up on the screen the federal regulation that allows employers to disregard that early clock-in time or on the back end, a late checkout time, as long as it ends up equaling out and that the employee is actually not performing any work during those minutes early or late at the end of the day. And we were relying on this regulation to argue the fact that, hey, we paid people for the time that they were worked, and the government, again, the investigator is getting through interviews that we have people who are telling us that they are actually doing, when they're reviewing plans and specs and drawings and they're gathering tools, materials, equipment for the day, that's work, and they need to be compensated for it. And this regulation that you want to rely on, Mr. Siegal, is not applicable in a situation where they are actually performing work. And what we did to try to get around this issue is obtain affidavits from some of our employees to attest to the fact, and this was a company that paid very well. The wages that were paid were well above what market rate was in our geographical area here, and the employees were grateful for that. And we had several employees that were identified as having uncompensated work time provide affidavits where they were attesting that, no, I wasn't performing any work prior to 7 o'clock. And that went a long way with our current employees. But the look-back period for these wage and hour audits is a 2-year look-back. They look back through 2 years of payroll records, and they'll include a third year if they believe the violation was willful. And if you go back, if I go back to the document request, they're asking for payroll records that go beyond just the current year, because thereafter, here it is right here, birth dates. Well, it's asking for employees who worked during the last two years, And it's also asking for 1099 forms because they want to capture and look into whether you're properly classifying independent contractors as independent contractors. And where I'm going with this is your former employees are subject to interview as well, and they're getting this information from your payroll records, they're getting addresses, and we had people that were interviewed that were no longer employed by us that obviously see dollars signs when the investigator is asking, well, were you performing any work that you weren't compensated for? And that's what happened. They had that proof, and they had statements from former employees that said, hey, we were working. And oh, by the way, when we added in this time that the government was taking the position was uncompensated, these people were already working 40-hour work weeks. So this additional time that the government was saying, hey, you didn't pay your employee for this working time, we're going to add it back in, and this is going to put that employee into overtime. And what you see up on my screen is before we got into any kind of negotiation and before we procured any affidavits, the original back wage assessment was $89,000. That is, they identified, I think, 30 employees that were owed back wages, and the initial assessment, $89,000. And I will tell you that to jump down to my fourth bullet point, liquidated damages, in a wage and hour proceeding like this, if your company is found to owe back wages, the amount owed is automatically doubled. It's automatically doubled, and that's just the law. Unless you can have an argument that, hey, we got advice from an attorney and we relied on the attorney's advice, you're stuck with an automatic doubling of the back wage assessment. And in this case, we were looking at $89,000 times 2. And it was after that point that we went back to our current employees and procured affidavits that reduced the back wage penalty to $37,000, doubled, it was $74,000. What could we have done differently in terms of the lessons that were learned? Well, one, we had this employment policy that talked about time clocks in our handbook. We just didn't go about enforcing it. And anytime you have a lax enforcement of any employment-related policy, it's going to invite problems, whether that's in the context of a wage and hour issue, a safety issue, a harassment or discrimination issue. It becomes critical to make sure you are following your employment policies that presumably are drafted in a way to avoid liability. And in fact, this time clock policy was consistent with the federal regulation that would have allowed the company to disregard that excess time on the back end or the front end as long as the employees weren't working. If in fact they really made a conscious decision to waive the policy and you had employees showing up and clocking in at 6:30, then it was on the company through its person in charge, the foreman, to make sure that those employees were not performing any work between the time they checked in at 7 a.m. And while I'm talking about it to you guys in the context of this particular wage and hour claim that involved a time clock, I could have just as easily thrown up a case I've handled time and time again that involves some kind of carpooling arrangement where you have employees arrive at your office to take the carpooling arrangement you're offering to the job site. And while the employees are waiting for the ride to the job site, all of a sudden they're sweeping your floors, they're loading the truck. Now, if you have that situation, the employees are on the clock when they're doing that prep work, and when they're driving the car in the carpool as a passenger from your office to the job site, that becomes compensable work time because their workday has already started. As opposed to a situation where they take you up on your carpooling offer and you keep them in the break room where they're not doing any work, and then the ride leaves, they're not getting paid as passengers on that ride because it's considered home to work travel. You're making it optional whether they show up at your office to take the ride. They're not required. It's optional. You have people take you up on your offer. As long as they're not doing any work waiting for the ride, just like here, if they weren't doing any work until they hit 7 o'clock, they would have been okay. There would have been no back wage liability. So I'm giving, well, again, I talk about a time clock, understanding that not everybody is using a time clock. I mentioned the carpooling arrangement because it's where I've dealt with it. And it tends to be, the carpooling arrangement seems to be used with some prevalence among our roofing contractor clients. So that is the story of the time clock, and I will ask if there are any questions here yet, John, as I transition to what I call the case of the disabled foreman.
No questions yet. I'll give a moment to type some in. If anyone has a question, please enter it in the chat box or the questions box.
Yeah, and John, if one pops up, just interrupt me as regarding the time clock issue on the wage and hour issue. Just interrupt me and we'll address it.
Okay, perfect.
The next case I want to talk about, I call it the case of the disabled foreman. And this particular client was in the utility contracting business, and they have a foreman who obviously heads up a utility contracting crew. And the foreman comes to, actually what happens is the foreman has some kind of diabetic seizure while in his truck on the job site. And the EMS is called. He is goes to the hospital. Of course, he's in the hospital a couple days. He goes to see a doctor after he comes out of the hospital, and the doctor tells him, given his diabetic condition, he is going to need to undergo dialysis a couple of times a week. And the particular dialysis he was going to need would have required him, or did require him, to arrive for his treatment, or leave work, arrive for his treatment at 5 p.m. He would have had to leave work at 4:30, and the company's workday goes through 5:30, but they are often, it's not infrequently, that the company has emergency situations where the crew needs to stay later than their normal stop work time. And the company articulated a position that, hey, before getting into the details of the claim, the company's position was, hey, the company's crews, plural. We don't allow our crews to work without the foreman being present. And when So if the foreman has to leave to go to a doctor's appointment or the dialysis treatment, the crew is not going to be able to continue work, and will have the crew members are going to be short on hours if this employee needs to leave early on certain days of the week for their dialysis treatment. So the employee that is suffering from diabetes with this dialysis prescription goes to the employer and makes this request to be what is under the law, and you have to look at it in the confines of, this is an Americans with Disabilities Act scenario. The individual suffering from the diabetic condition certainly is going to qualify under the Americans with Disabilities Act as it's been amended since 2008. Almost every medical condition qualifies as a disability, and that's because the law is intending, or the Department of Labor wants the focus on not whether the individual is disabled, but whether the employer can provide a reasonable accommodation that would allow the individual to perform the essential functions of their job. And in this instance, the employee comes to the employer and says, hey, I've got this condition. I would like for you to allow me to leave work early to have my dialysis treatment. And the company says, okay, we will allow it, except we need your promise that you will, despite having dialysis treatment scheduled on any particular day, if there is an emergency situation, we need your commitment that you will stay through the emergencies so the crew can complete the work. And the individual refuses and says, no, I need the dialysis treatment. You're being unreasonable and not accepting my proposed accommodation. and he resigns. And it's not soon after the employee resigns that he no surprise, after the fact, I have to say, I wasn't consulted on this until after the charge of discrimination came in. That's my own self-serving statement there, but it's true nonetheless. Anyway, the individual files a charge of discrimination, and it's up on your screen with the EEOC, claiming he was discriminated against and, in fact, basically constructively discharged because of his disability. And he indicates there, you can read it yourself, he was admitted to the hospital, as I explained. He had some kind of diabetic seizure on the job in his truck. And when he comes out of the treatment, as it indicates, this regular medical treatment he speaks to was the dialysis. And he asks, as I noted, he wants to be able to leave at 4:30 p.m. twice a week for those treatments. And he does admit, and this was a point that we picked up on when we responded to the charge of discrimination. We made a big point in his relying on his own statement to note that, hey, the normal workday is through 5:30, and he even says sometimes we work until 6. And he notes in his charge that because I'm only really asking to get off an hour or 90 minutes early, it didn't seem as though it would negatively impact business operations. Well, we jumped all over that and explained that, wait, in fact, the crew can't work, and we have these emergency situations that need to get done, and the foreman needs to be there. And he makes note that he even offered to make up the time. But the issue wasn't on our end, him making up the time. It was when there was work that needed to get done, we needed him there, and we needed that to trump any dialysis he would have otherwise had scheduled. And he notes that we take exception to the second statement. He says he was notified as he was terminated. It was that he quit. Doesn't really change the analysis that follows. And then he concludes that he feels he was discriminated against. Now, I do a lot of these charges of discrimination, and what concerned me right off the bat was I can tell from just what appears on your screen that the employee was already working with an attorney. Typically, when you have an employee creating a charge of discrimination, it's not bullet pointed like this, and there are terminologies that are being used here, reasonable accommodation, that you wouldn't expect a foreman, whether it's a roofing contractor or any other trade, to be aware of. So I picked up early on that there was an attorney involved, which I was guessing, but it caused me some concern. Let me step back and just explain the law here. When the employee came in and identified this medical condition and was making a request for, he didn't come out and say, hey, I need you to give me this, I have an accommodation request, and I think it's reasonable. He just came out and said, I'm going to need to leave work at 4:30. And one mistake the company made really at the get-go here is not understanding that there's a duty when the employee presents with a disability and is claiming that they need an accommodation in order to perform the essential functions of their job. Because you need to keep in mind that the only individual that's protected under the Americans with Disabilities Act is called a qualified individual with a disability. And an individual with a disability is only considered qualified if they're able to perform the essential functions of the job with or without reasonable accommodation. And the employee here was saying, hey, I'll be able to make my hours, I'll even work weekends to make up, but I need this accommodation of being able to attend my dialysis treatment. And the company didn't engage in you're not at any point as an employer dealing with a similar situation to accept the employee's proffered accommodation. You have the duty to only engage in an interactive dialogue. You can weigh and consider what the employee is suggesting. Ultimately, your duty is only to provide an accommodation that's reasonable if there's one that exists that allows the employee to perform the essential functions of the job. One mistake here was they heard the employee's request and no alternatives were discussed. It was a zero-sum game. They were either they told them no deal in those situations where we have an emergency. The only argument that the argument that the company was really trying to make, if we look at it in the confines of the law itself, is to say, hey, if you're going to insist, Mr. Employee, on leaving work at 4:30 when we're dealing with an emergency, that request for an accommodation is unreasonable, and the standard is it would cause us an undue hardship. We can't perform, this is the company's position. I'm going to give you the smoking gun here in a second. And just to tell you, we end up losing and settling this case. I'm going to get to the results here in a second. Ultimately, we say that, hey, we're telling him, in effect, that allowing you this time away from work when we're dealing with an emergency situation rises to the level of an undue hardship. And that undue hardship is the terminology in the law. And if an accommodation request imposes an undue hardship, it's not reasonable, and you don't have to provide it. Let me cut to a chase, and let me give you the conclusion, and then I'll dive into the details and bring us back to the screen. The biggest mistake the company made was not dotting I's and crossing T's in terms of the position it was taking. Because jumping ahead, the EEOC conducted a mini investigation here, much like the wage and hour investigator from our time clock case. And what they learned from interviewing employees, coworkers, was that sometimes there were two different instances where the crew was performing work without the foreman present. One, there were sometimes jobs where the site was big enough where they had basically two crews on site. Think about your roofing projects that deal with two buildings, two roofs, maybe you've got two crews. And there was evidence in the record that the foreman visited with one of the crews, leaving the other crew to continue with their work. And then there was, we were being told, we never got privy to the actual written statements. Everything was being represented to us both by the claimant's attorney and the EEOC investigator that they had this evidence. The second point of which was there were times where the foreman actually left the site and the crew continued to work. And there were some payroll records that gave some credence to this. We didn't just take the attorney's word or the investigator's word. We listened to what they said and we dived back into our payroll records. And again, one of the earlier mistakes was if they were going to take a position that, hey, crews don't work without foremen, they really should have made sure, it's easy for me to say in hindsight, if they were going to call me and say, Philip, we can't accommodate this request, we want to tell them no because we can't have the crew working with the foreman. Again, easy for me to say now, but I likely would have said, well, let's make sure the payroll records confirm that. How are people recording their time? I just want to make sure we don't have any crew members with recorded time where the foreman doesn't have recorded time. And we would have caught that. And that really goes to my failure to investigate bullet point right here. The first bullet point touches on one of my 10 most common mistakes that are made by roofing contractors in labor and employment. And that is not having a written job description that defined the essential functions. I'm not saying the case would have been a winner given what we were hearing from the interviews. The case does settle, and I'll get to that slide here in just a minute. But we probably would have settled it on cheaper terms if we had the job description that said, hey, for foreman, you need to be present when the when the crew has to work, and an essential function of the job is to stay for emergency late hours. Sometime work goes into the night and your attendance is mandatory. A written job description that just identified what the company believed were the essential functions would have been a critical piece of evidence to rely on in this case, and we didn't have it. In this instance also, because given that the employee had that seizure, we could have had a better record from the get-go. In this instance, the employer, and again, this is also one of my top 10 mistakes roofing contractors are making in labor and employment, not understanding what to do with the current employee who has a medical condition that's observed on a job site. I speak about it in the context of an epileptic seizure. This was diabetically related. Nonetheless, the company had within its power to send the employee to the doctor of its choosing, as long as that doctor specialized in the medical condition at issue. And they were unaware that they had that tool in their toolbox that could have perhaps created a better fact record going forward. They're not understanding what to do with that employee who exhibits a medical condition. Objective evidence, everybody sees that there's a medical condition and it pertains to safety. The lesson learned is you have the power to control that employee and the doctor they go to see. Again, employer, doctor, as long as the doctor specializes in the medical condition. And what we would have done also, and it goes back to not having the job description, we would have in those instances sent the employee to our doctor with a questionnaire that basically asks, separate from whether the employee can perform the job, can he do it safely? Is this employee going to be a direct threat to their safety or the safety of others if we allow them to work, period? And some companies, the mistake is made in assuming that there's a safety issue when that standard of there being a direct threat, if you dive into the federal regulations that define direct threat, it's that there needs to be a significant risk of substantial harm, and we need the medical provider to opine on that, not the company can't make that decision on its own. And again, this was just a lost opportunity for the company, not understanding how to deal with the situation involving a current employee with a medical condition. And in light of not having the job description, making it hard to argue what really were the essential functions, this issue about employees that were interviewed saying there were times when we worked without the foreman present and it seeming to have some support through the payroll records, the EEOC actually determines, and it doesn't happen often. 99% of these cases, the EEOC issues a notice of right to sue letter. And then the employee or the claimant has 90 days to file a lawsuit, and they need to find an attorney. These attorneys take these on contingency fee basis. They're going to look at the position statement, and if they see it's a loser case, they're not going to make any investment. Here, clearly with the attorney involved in the beginning, he saw an opportunity for a quick payday. And sure enough, the EEOC sees that there's the potential for a claim here. And they issue this determination, and they say, hey, our proffered reason doesn't withstand scrutiny and appears to be a pretext for discrimination, that we really did discriminate, and these reasons we're offering, we don't mean it. We're coming up with it just to try to get out from liability here. Well, anytime the EEOC finds potential cause, they're obligated to go through this conciliatory process before they file a lawsuit. The EEOC can file a lawsuit in the name of the EEOC, and that's where this was headed. But we took the EEOC's offer to participate in this conciliatory method, which really is mediation. And a mediator did mediate this case, and ultimately this case settles with the company paying $65,000 in what was back wages and attorney's fees. The attorney took home $21,000 and change there. And I will tell you, and I'm curious the reaction is on the other end of the line here, but I was very concerned that this case was going to need $100,000 to settle. Because in my experience, which goes 22 years now, where there is merit in a discrimination claim, or really I can tell you from the one case I handled that went to the summary judgment stage and we had it tossed out. We won on summary judgment, which means the case didn't even get to the jury. We told the judge, Your Honor, these facts in this particular not the case we're talking about now, another one, I'm just proving a point. Your Honor, these facts are undisputed and there's no way the plaintiff can win this case. We're entitled to judgment as a matter of law. And I've had the instance where the judge agreed with me and threw the case out. And I will tell you, the client paid close to $100,000 to make that case go away. They were going forward on principle. There was no way they were going to pay that employee who happened to have tested positive for drug use after the GPS record showed this service crew going places it shouldn't have been that seemed to be drug-infested neighborhoods. and then on his way to be drug tested by the company says he's going to test positive and handwrites out a resignation, and then has the audacity, after submitting the resignation, to bring a claim of discrimination alleging that he was terminated because in this particular case he had a heart condition a month earlier, and a supervisor made a comment, are you going to be able to handle the heat, when we get to August with your condition? Anyway, we got it tossed out. The point I'm making is it costs near $100,000. And here we had an attorney involved, and I'm thinking this attorney does these cases routinely. He knows it's going to cost my client $100,000 to get to summary judgment, and this is a case where we're probably not going to get out on summary judgment. This case would likely get to a jury. Again, I thought the deal, and I know you're going to cringe, was a good one at $65,000. I expected a lot worse. Now, the other point I look to make in handling these cases, or as I talk about this company didn't have any insurance to cover this type of claim, so all of this was paid out of pocket. I will tell you, there is insurance that you can have for these types of employment-related claims, and it's called Employment Practices Liability Insurance. Employment Practices Liability Insurance, the acronym is EPLI. Those in the insurance business sometimes refer to it as sleep insurance because it's not terribly expensive, but it'll help you sleep better, especially if you're in the throes of one of these discrimination claims. And when I'm live giving these presentations, I'm asking, is anybody who's carrying EPLI coverage? I'm always surprised to see not a lot of show of hands. So something for you to discuss with your agent if you've got that concern. Again, I refer to it also as sleep insurance. It's not expensive, and it does provide defense coverage. They do hire an attorney for you that they've got on a panel that has experience handling these claims. You're going to have the deductible, of course, but the insurance company is otherwise paying the attorney. Okay, John, any questions?
Nope, no questions so far.
Okay, we'll keep rolling here. I am going to move into the OSHA context, and I've got two cases to share with you. One I refer to as the case of the snooping neighbor, and this case involves, and the message is taught under the controlling employer liability theory under OSHA. Anytime, and this does involve a roofing contractor, this case, anytime you are on a construction project where there is more than one company, and I want you to consider, as it pertains to this case, where there is only the roofing work to be done, but you're subcontracting the work out. So automatically right there, in OSHA's eyes, you've got two companies on site. Even if your company doesn't have a physical presence, isn't doing any of the work, except sending one quality control guy out to the job site to, one, make sure the subcontractor is present, and then to just see from 10,000 feet that the work is being performed correctly and safely. Well, again, in that situation, which is somewhat typical, and that is the situation I'm going to get into here, that is going to involve the multi-employer worksite doctrine. There are 4 employers on a worksite with multi-employers that can potentially be cited. You've got the correcting employer, the person who can correct the hazard, the creating employer, the entity that creates the hazard, the exposing employer, that's the entity whose employees are exposed to the hazard, and then what I'm going to talk about lastly, the controlling employer, the employer who either through contract has responsibility for safety on the job site as a whole, or has assumed through its actions responsibility for safety on the job site. And if you have if you are the controlling employer, either because of your contract or you've taken it upon yourself, that doesn't mean that you're going to get cited if there's a violation. But if you are a controlling employer, you have a certain duty to meet to avoid being cited. What is the duty? Well, you have a duty to act reasonably to detect and abate violations when they're discovered. You have to act reasonably to prevent, detect, and abate violations of the various trades on the site that you are deemed to be controlling. And if you're acting reasonable Even if you've got a trade on site that commits a fall protection violation, if you've acted reasonably in preventing and detecting and then making sure violations are abated, then you've met your duty as the controlling employer and you won't be cited. The individual whose employee is committing the violation is the exposing employer. They're going to get cited. We're looking to avoid a citation as the controlling employer. Well, in this particular instance, we had a roofing contractor client on a residential project in a subdivision. And as it was, our roofing contractor client subbed out the work. They had one quality control guy arrive on site. He's there first thing in the morning. Well, not first thing in the morning. The subcontractor crew had actually started work. And lo and behold, the quality control guy shows up and he sees that someone is up on the roof not properly tied off. And he is there. This is the first day of the job, and it's a one-day job. These are important points as the story continues. And he pulls the crew down, subcontractor crew down, instructs them on proper use of fall protection, sends them back to the roof, and doesn't leave the job site until he sees that everybody is properly tied off. Once everybody's properly tied off, the work is continuing. There's also a ladder involved. The ladder is set up properly. He notes that, and then he's off to the rest of his day. Well, as it turns out, a few hours later, there is an individual taking a stroll through the neighborhood, and he stumbles upon this house where our client and the subcontractor is doing the work, and he sees that people are not being safe, and he takes pictures. It's this concerned citizen that is taking pictures of the roofing crew on the roof, and he also happened to capture the ladder which moved between the time when our client quality control guy was there and these photos are taken. This neighbor, unbelievably, at least in my experience, goes a step further and sends the photos to OSHA. Can't make this stuff up. Sends the photos to OSHA, and sure enough, OSHA issues a citation not only to the subcontractor, but also to our client. And they issue the citation to our client as the controlling employer. There's no dispute that this was a subcontractor. In other words, nobody is arguing that we misclassified them and these are really our employees. It was undisputed that these people were a separate company and they were properly classified as subcontractors. We're being cited for their fall protection violation right here, and we're being cited for the ladder violation right here, both as the controlling employer. Actually, there was a second ladder violation, and I've got it up on the screen as well. 2 ladder violations, 1 fall protection violation, all serious. And if we accept these and just pay the penalty, we're on the hook for a potential repeat violation if we have a fall protection violation or ladder issue over the next 5 years. And as a roofing contractor, I'm telling you already know, ladder violations and fall protection violations are among the most common. So this was a big deal in terms of potential exposure down the line, because these penalty amounts you're seeing, they increase tenfold with the repeat violation. So we were concerned. Now, I already indicated to you that, I'm going backwards. I already indicated to you that the quality control guy, we get cited. We get cited, and we ultimately try to meet with the area office in an informal conference, and we explained to them the history we've had with this company. And this is really important. While this was a one-day job, this particular subcontractor, over the 3 prior years, we had done a total of 21 jobs with them. Everything I'm about to tell you was supported by documentary evidence. We had 21 jobs with them over the prior 3 years. The same quality control guy had been with our client for the 3 years, was very familiar with the subcontractor. He was able to testify under oath that I routinely am working with this subcontractor. They've never been unsafe. I've never had an issue. I happen to have had an issue that morning, but I acted reasonably. I addressed it right away. I pulled them down from the roof. Not only that, but beyond the supervisor, doing these daily inspections over the 21 jobs, he actually completed 3 formal safety inspection reports, actually safety checklists, so to speak, that we also had as evidence. And then even better, We had one third party, it was the Hendrick Associates firm, I'm sure you're all familiar with up there. They did one formal inspection of this particular subcontractor crew and passed with flying colors. So we go to the informal conference, we ask them to vacate the citation in its entirety. We say we met our duty. The area office refuses to do that. And in fact, we contest the citation, and the OSHA issues a complaint, and they argue that we are being cited as the controlling employer because we assumed responsibility through our daily on-site inspections with the quality control guy, and then in our contract upstream with the homeowner, we promised a safe work site. So beyond just the quality control guy saying, I've had a long history, no issues, I've got 3 documented safety inspections that are written evidence of that, and we have the one formal inspection by the third-party crew. The company also had, as we get to this part of the proceedings, I'm working with the attorney for the government. I'm sending him the subcontract, and I'm showing him, hey, we've got all of the safety is pushed down, responsibility is pushed down on the subcontractor. We give our safety manual to our subcontractor, knowing we have controlling employer responsibility. We even offer as an option training to our subcontractors. They were worried about the misclassification issues, so they made it optional. I know no discipline was offered here. OSHA wanted to argue that cuts the other way. Well, I explained we're not going to be administering discipline against our subcontractors' employees. I included as a bullet point here because it's like the OSHA wanted us to have a means to penalize the subcontractor. And I jumped all over that because I said, penalize the subcontractor. We never worked with them again after this job once we knew we were being cited because of an OSHA violation. We had a zero tolerance policy with our subcontractors. So the solicitor's hearing all this, and I actually had the opportunity to respond to written interrogatories and put it out there in black and white for him to read it. He calls me up and says, hey, we'll drop the case, but you have to drop your claim for attorney's fees. We were pursuing a claim for attorney's fees under the Equal Access to Justice Act, which is a means to get your attorney's fees in an OSHA case if it's being prosecuted in bad faith. You can't be too big of a company. It's only available to certain size companies. But we agreed to that. To make it go away, OSHA dropped the case in its entirety with no strings attached. We didn't have to provide any training, didn't have to submit any safety reports, just dismissed in exchange for our dropping the unforeseeable employee misconduct. Excuse me, dropping our attorney's fees case. Okay, let me move forward in the interest of time here to the last case I want to talk about, then I'll cover a couple frequently asked questions. This last case stays within the OSHA confines, and it involves the unforeseeable employee misconduct defense. And again, one of the more common mistakes I speak about that roofing contractors are making is thinking you have a strong misconduct defense when you really don't. Well, I can tell you this case was a winner. So this case presents an example in the face of what seemed like bad facts of what is a good misconduct defense. So let me add some meat to that. I will tell you the company was on, it was in a neighborhood, it was new subdivision construction. They had a job that involved 2 new homes being built across the street from each other. And what happens is, as it is, 2 crew members arrive at one of the jobs, one of the homes. The foreman arrives a little bit later. The weather isn't good. The 2 crew members had not yet started working. The foreman gets to this house. He says, hey, let's take an early lunch given the weather. Just do me a favor and move the ladder. The ladder needed to be moved in some form or fashion. He gives that instruction, which didn't require any accessing of the roof, which is an important point. And then the foreman goes to the other house across the street where he's parked his truck. And he's waiting for these guys to come over to his side of the street so they can go to lunch. Well, lo and behold, as they're moving the ladder, the employees take it upon themselves. They see up on the roof some broken tiles. So they take it upon themselves, unbeknownst to my foreman, they go up on the roof to take care of this tile issue, and just bad luck, the OSHA's driving through as they're up there. And consequently, they're up there without fall protection. the company gets a 501b10 violation. And it is a repeat violation. And the reason why it was a repeat violation is because this company had 3 prior OSHA fall protection violations over the preceding most recent 12 months. And you're thinking, how could this company have won on unforeseeable employee misconduct defense if this was their 4th fall protection violation within 12 months? Well, this occurred during the month of May. I'm going to come back to that. Let me also say, stick on point here. This lack of knowledge defense, one of the defenses we made was, the foreman having gone across the street and given the steep slope roof, and that these guys were on the back side of the roof across the street, my foreman did not have actual knowledge that these guys were on the roof. And we were arguing that we didn't even, OSHA can't argue that we have constructive knowledge, because given the instruction he gave, he had no reason to believe that these guys were going to access the roof, period. So part of OSHA's prima facie case, before the burden shifts to us to argue an affirmative defense, such as unforeseeable employee misconduct, OSHA needs to prove that we knew or should have known of the violation. So we argued a lack of knowledge. Our fallback was, this was unforeseeable employee misconduct. We provide the training. We have the work rules, we provide the training, we self-inspect our job sites, and we discipline employees when violations are discovered. Now, how could we have such a strong misconduct defense if we had these prior violations? Well, as it was, I told you this particular, or the most recent, we had the last of the 3 prior violations occurred in the month of May. The following September, not 4 months later, we hire, understanding we got problems, we hire a full-time safety director that implements an exhaustive, detailed fall protection safety program, period. Written fall protection plan, regular safety meetings of the production crews and the service crews, monthly in the office, toolbox talks on sites. He is conducting his own random inspections to the tune of at least 25% of his work week is spent doing these random inspections, 10 to 16 inspections of each work site. And since his hiring, from September to the following May, they actually had 4 OSHA inspections where the company did not receive an OSHA citation. They did, though, as a result of his own internal inspections, there was one violation that was discovered, and we administered what we argued was appropriate discipline in the form of a verbal reprimand, and we documented it. The verbal reprimand was memorialized in writing. As it concerns the actual violation that resulted in us even having to argue this defense, we terminated the 2 employees that accessed the roof. The foreman, who was just in charge, and again, we were arguing, didn't even see it, was disciplined, didn't get terminated, but was disciplined. And again, I'm noting a second time here that we did have documentation showing we provided the training, and the individuals, the 2 that were on the roof, had attended the training. That's your best evidence to meet the training element, is to have an agenda that identifies that, in this example, what's fall protections being provided, an attendance sheet where we can show the inspector or the solicitor, the attorney, here's where these guys signed, they actually attended training. We thought the misconduct defense was very strong. I was in this case from the beginning, and I felt it was strong enough that whatever proposal was being made to settle the case wasn't good enough. It was unreasonable. And we made the decision to contest the case, and despite an attorney being involved for the government, they were still being unreasonable. This is a case that went all the way to an administrative hearing. We had a full trial before an administrative law judge. And after the judge, in this case, there were witnesses, the whole 9 yards. And the judge at this trial level rules in our favor on both arguments. He says, given the time of exposure and the foreman was across the street and what this company does in terms of its safety, the foreman didn't have actual knowledge, and there's no argument that the foreman knew or should have known, have constructive knowledge. And he also ruled in our favor on the unforeseeable employee misconduct defense. Well, the government, and in this case, this is actually a Kentucky OSHA, state-administered OSHA case. It doesn't matter that it was in Kentucky. The same could hold true in federal. The solicitor files an appeal with the review commission at the federal level, but would have been the Federal Review Commission. Here, Kentucky has their state review commission, and the government appeals. And the state review commission reviews the evidence de novo, meaning they look at it new, fresh. They're not at all bound to what the hearing officer who observed the witnesses provided or how he ruled. It's all starting over based on written submissions. The review commission does not get to see the witnesses. To cut to the end here, the review commission says, well, one, we believe that the foreman should have known, or that they didn't act diligently to discover violations in the unforeseeable employee misconduct defense, because there was a period of time at the beginning of the day where the employees were there without the foreman being present. And the review commission relies on that fact to both argue that, no, the company did have knowledge, and because the company had knowledge, the burden shifted to the company to argue its misconduct defense. And the review commission says, we acknowledge you have the work rule, we acknowledge you're providing the training, but you lose on the third element. You didn't take effective steps to discover violations because basically you allowed work to take place without the foreman present. And they don't even get to the fourth element of the defense because we lose on element number 3. Well, we have issue with that. Now we're on the losing side of things. And we have to appeal to, if we were in federal system, we would have been appealing to the Federal Court of Appeals. Because we're in the state system, we had to apply for appellate relief at the Kentucky Court of Appeals. And we argued with the Kentucky Court of Appeals about whether, and the standard is, did the review commission have substantial evidence to rely on to support each of its conclusions? And the Court of Appeals says, yes, on the knowledge issue, we think there was substantial evidence for the review commission to support its conclusion on the knowledge issue, but we don't think they had substantial evidence to rule against the company on the third element of the misconduct defense. And in fact, given everything the safety inspector did, the safety director, the 10 to 15 hours a week inspecting sites, 10 to 16 inspections per work site, meets the third element of the defense. So the Court of Appeals sends the case back to the review commission to have the review commission render an opinion on whether the company met its burden on the fourth element, whether it administered effective discipline. And the review commission rules in our favor. It says, yes, the company did effectively administer discipline. It wins on the misconduct defense. So we're back at the review commission, and this time we're the winner. Well, unbelievably, the government files an appeal back to the Kentucky Court of Appeals, and sure enough, this case is actually decided by the Court of Appeals in our favor. There is a written decision out there on it, and the case ends. Interestingly, I went through this slide except the bullet point. You're hearing all this, and you're probably wondering how long did it take and what did it cost? Well, it took 6.5 years from citation issuance until the final appellate ruling was published. And I will tell you, in terms of cost, it would have been more expensive for them to be on the hook for a repeat and get dinged for it than it was the attorney's fees. And I did, and I feel compelled to note, I kept my attorney's fees at the rate I was billing at when the citation came in for the entire 6.5 years. Just consider me a good guy. So we did that, and we prevailed. It was worth the investment and the time, because I'll go back to the point I made earlier. We really had little choice in the matter with how unreasonable OSHA was in settlement negotiation. We weren't going to get out from any of the fall protection violations was the issue. They were willing to reduce the penalty, not by much, but we were going to be on the hook for a future repeat. All right, I know I'm at 2 o'clock. I do want to run through quickly. I've just got a couple of questions or slides that I want to cover that I'm dealing with a lot that I think are practical. This is what I've got up on your screen is particularly timely, and I promise to wrap it up here in the next 10 minutes. For those of you that have received a no-match letter, I want to talk about how to respond. If you haven't yet received one, I can tell you that as of March 1st, 2019, Social Security Administration is back issuing no-match letters. And the question comes, hey, what do we do when we get this letter, this no-match letter from Social Security Administration? Well, if you get the letter, the easy answer is just follow the instructions in the letter. What's lost in the mix is the potential immigration issue that comes out of the no-match letter. And in fact, if you are ever under an I-9 audit by Immigration's Customs Enforcement, it comes with a subpoena, and among the documents the subpoena asks for are copies of no-match letters you would have gotten from Social Security. Why are they asking for no-match letters? They're trying to determine whether you had constructive knowledge that some of your employees, that is, the employees who are identified in the no-match letter as having provided Social Security numbers to you that don't match with what the government has, and therefore aren't being properly credited their Social Security earnings. The ICE auditor wants to say, well, did you have constructive knowledge that maybe some of your workers were not authorized to be working in the United States, and they're focusing on those of your workers who produced, for Section 2 purposes of the I-9, a Social Security card to prove employment authorization status. And for those employees that produce a Social Security card, if any of those employees are on the no-match letter, ICE wants to argue that, hey, maybe you were on notice that you could no longer rely on that Social Security card. So you had a duty to go back to the employee and ask them for a different List C document or a List A document proving identity and work authorization status. So to tie this back into the question, for the Social Security Administration issue, follow the directions in the letter, which basically say go back to the employee and have the employee go about correcting it. I want you to consider the immigration issue. And my advice is to make sure you're documenting every follow-up with the employee. Again, you're asking the employee, have you gotten it corrected? I want to make sure you're being properly credited your Social Security earnings. And you need to be making a memo in your file if you're in this situation every time you go to follow up with the employee. And my advice is if we get to 60, 90 days out, there's no black and white, and it's still not resolved, we'll want to take a look at that individual's I-9 form. And if that individual's form showed they used a Social Security card for Section 2, my instruction to you to give to that employee is, hey, listen, you need to get it figured out here in the next 30 days, because if you don't, I'm not going to be able to rely on the Social Security card any longer. You used that card for Section 2 purposes. If you don't have it resolved in 30 days, I'm going to be asking you for a different List C document that I can accept and substitute out on the form, or a List A document. And if it's not resolved after you've given that warning and the time has passed, and the individual is not able to produce that second List C document or the List A document, you are in a position where you are going to have to terminate that employee's employment. And if you follow my advice, we're really 4 months down the road. We're risking that the ICE auditor would think that's too long. I don't think so, and I would fight real zealously on your behalf if we were being presented with that argument. And one of the tools of evidence we would have in our corner would be the Social Security Administration letter itself. It advises not to take any adverse action against the employee based on the letter alone. Of course, if you've got the letter plus the I-9, you're not acting on the letter alone to get out from that issue with SSA. But it's not why I'm bringing it up now is because companies aren't considering that immigration component to it. On the second component here, Is it legal for us to request and take a copy of the Social Security, there's a typo there, card from our employees? The answer is somewhat tricky. You aren't, and this actually goes backward from all the logic I just got done articulating. Unless you're an E-Verify employer, you cannot require the employee to either write down their Social Security number in Section 1 of the I-9 form, which calls for it, or, and you can never demand the Social Security card for Section 2 purposes. But I'm bringing it up because I've had issues with companies that are not E-Verify participants getting back the I-9 from the employee who's completed Section 1 and has written NA in the Social Security section of that Section 1. And the employer is going back insisting on getting the Social Security number, and that can create an issue. If you are an E-Verify employer, you can require the employee to identify their Social Security number in Section 1, but getting Section 2, you can't demand that we only take Social Security cards, List C documents. Okay. I've got a third question I'll get to real quickly. This second question I kind of talked about a little bit earlier. If we have an employee that has been out of work for an extended period of time and you are continuing to carry that employee's medical benefits, the employer portion, and you're calling me and asking, hey, I would like to terminate this employee, or how long do I need to keep them, just like the question says, how long do I need to keep them on my payroll? Oh, by the way, I'm carrying their premiums as I do this. It's an Americans with Disabilities Act and FMLA analysis. And unless you're employing 50 or more employees, you don't have to worry about the Family Medical Leave Act. If you do have to worry about the Family Medical Leave Act because you are employing 50 more employees, and this individual with the medical condition qualifies for FMLA protection because they've worked for you for at least a year and did 1,250 hours in the most recent 12 months, then you have to consider that this worker gets up to 3 months of unpaid leave. And you would be required to keep them on your payroll through those 12 weeks. 3 months, 12 weeks of unpaid leave. If we get to the end of the FMLA leave, or you don't have to worry about FMLA either because you're not big enough or the employee isn't protected, then in either scenario, you're left dealing with the Americans with Disabilities Act analysis, which is, can the employee perform the essential functions of the job with or without reasonable accommodation? And if attendance is an essential function of the job and the employee can't come to work, then the employee is not entitled to any protection under the Americans with Disabilities Act, and you'd be entitled to terminate that employee's employment. We would want to make sure, though, that this employee, whether it's at the end of their FMLA exhausted leave or they're just coming to you, they have no FMLA protection, and they're saying, hey, I've got this condition, I'll be back in 2 weeks. I'm giving you a date certain, Mr. Employer, that I'm going to be back. Well, if you're given a date certain, you need to consider whether allowing the additional leave after FMLA leave or allowing leave period, if we're working with someone without FMLA leave, is the reasonable accommodation. And in this example, 2 weeks, I'm going to push you real hard to allow it to avoid a litigation. But what's key is they're giving you a definitive date of return. If they're telling you, I don't know when I'm going to come back, you're never going to be required to keep a job open indefinitely. You would be entitled to terminate that employee's employment. If it's, I'll need to be back in 3 months, there is at least one case out there that says, hey, the Americans with Disabilities Act is not a leave statute. 3 months is unreasonable on its face. Employer isn't going to have to accommodate that, even though the employee is giving a date certain. It's up to each company to decide for themselves whether the leave request creates an undue hardship. Can you go without the crew member for 3 months until they get better? Everybody has to answer that for themselves. The last question, I would like to know if we can find employees as long as they're non-exempt and still meet minimum wage requirements. This is primarily for safety violations. This goes into that misconduct defense I spoke about earlier. What is effective means of discipline? Well, the non-exempt employee, the hourly wage employee, under federal law, you can deduct that employee's wages, for example, $1 an hour for 30 days as an effective means of discipline. We will want to check state law to make sure you're not running into a state law issue in terms of that being an impermissible deduction from employee pay. But if you've got in most cases, if you've got the policy written either in a handbook or on an employee bulletin board, and the employee continues to work for you, they've impliedly consented to that deduction as a term and condition of their employment, and that would be a means by which you could administer the fine, as long as that fine doesn't have the effect of bringing the employee's wages below minimum wage for the work week. For your salaried exempt employees, if it's a major rule of significance involving safety, you could also deduct a full day's salary from the exempt employee for that violation of a major rule of significance, and without jeopardizing the salary basis component of the exemption under which you're putting that exempt employee. So that's it. I appreciate everybody's patience. I apologize for running over. I'm happy to stick around to answer any questions. And you can always shoot me an email directly. I've got my contact information on the screen. But thanks for your patience and sticking with me here to the end. And John, thank you for the opportunity. I really do appreciate it.
No, thanks, Philip. It was very interesting, all of the different cases. It's amazing what's going on out there. But thanks for filling us in. And yeah, if anyone has any questions, you can email Philip directly or reach out to me, and I'd be happy to put you in touch. Like I said, we have a recording of this entire webinar if you want to rewatch it, get a few more details out of it. Other than that, thanks for coming on, and look for the next webinar in a month or so.
Okay, have a good afternoon, everybody, and be safe. Thank you again.
Thank you. Bye-bye.